which we would like to welcome Kun Weerapat Pariyawong onto the program.
Good evening ครับคุณจรวีคุณสถาปัตย์
Good evening. First of all, we've been talking about this issue for several days, and could you explain to us the difference between the amnesty and royal pardon, which some of us have been using it mixed up?
Right. Well, the English terms comes from the foreign legal system. We have to be aware of the lenient differences between them. But in general, when we think of amnesty, let's think of the Greek root, which comes from the same root as amnesia. It simply means forgetting the crime. Let's forget that the crime happens and nobody has to worry about it. So it simply means that the crime, let's pretend that the crime never happened. Nobody has to pay for the price, and we all move on. That's amnesty. So in Thai, that would be closest to niratosakam, which simply means the crime never actually happened, forgetting the crime. But in the case, the current controversies before the Thai public right now is actually royal pardon, which is closer to what can be explained as forgiving, to provide forgiveness. And there are other sorts of related terms when we talk about this sort of clemency, leniency, providing forgiveness to convicted persons. It could be a commute of sentence, which is to reduce the severity, or it could be a reprieve of sentence, this is to delay the execution of the punishment. But what we are talking about right now is the royal pardon, that is to forgive.
So amnesty is actually for a person who has never done a crime before, and we can forgive them for a crime that has been committed?
Well, this is a tricky part. If we look at the Thai governing law, that is the Constitution and the Criminal Procedural Code, there is no requirement. There is no specific requirements that for someone to be royally pardoned, he or she must have already served some sentences. There is no such formal requirement. But there is an established practice for the past 50 or 60 years or so that the king has granted pardon, and long before the current king, in fact, that the Thai kings have practiced giving royal pardons before. When we talk about forgiving someone, we are talking about someone who deserves to be forgiven, someone who already admits to the crime, asks for forgiveness, and there are grounds to forgive him or her. For example, if we look at the past examples, we would see that someone who's very old, who has served sometimes in the prison, or someone who is severely ill, someone who has a contagious disease and shouldn't be kept in prison, otherwise he or she would infect other inmates, or someone who's still very young and too naive, and he should be given a second chance to try live his life. Right. So those are grounds for forgiveness. But when we talk about the current controversies concerning Mr. Thaksin Shinawatra, one has to bear in mind the fact that he's still a fugitive from the criminal conviction by the Thai court. Whether or not such status has any valid legal arguments or political arguments to be made is a different matter for the public to consider, because when we're talking about the forgiving someone, royally pardoning someone, it is in fact pardoning someone for the grounds for him to be forgiven, not just forgetting the crimes.
Right. Well, Kun Weerapat, talking about the process in an attempt to petition against the royal pardon, what's your view on this and its feasibility?
Well, I always enjoy the color of democracy. I always enjoy the fact that the citizens at present are very aware of their empowered participation in current politics. I think there's nothing wrong when the group goes out there peacefully protest to something that they deem inappropriate or morally or legally wrong. The problem is we have to remember this is a democratic society governed by the rule of law. We are not governed by the rule of satisfaction or happiness. You might not be satisfied or happy to see Mr. Thaksin being pardoned if the current controversy is proven to be true.
Right.
The law actually provides the government, the cabinet, the power to present the royal decree to the king, and the king has the prerogative to grant the pardon. Whether or not the king will consider the criterion presented by the government appropriate, that's the prerogative of the king. Now, when I'm saying that as a prerogative of the king or the discretion of the king, it's quite a tricky legal philosophical debate. Some people say that the king really has no room to exercise his discretion. But if you look at the actual experience of the current king, who's very wise and experienced during his time, he has in the past rejected, in a way, or refused to sign certain laws which proven to be wrong facially. That is, for example, if the law presented to His Majesty contains serious misspellings, he would catch it and he would refuse to sign it, which is a good thing for the head of the state. The Thai people should be proud of that fact. But in this case, we are talking about political controversies, and there are limits to, for what the king as the head of the state can do versus the prerogative of the head of the government, that is the prime minister.
Right. So you're saying that there is a possibility that even though this movement of the royal pardon has been endorsed to the king might not sign it?
Well, that is entirely possible. It already happened in the past, as I've said. And even if, assuming that for some reasons the government dares to present such controversial law to the king and the king somehow confirms and signs it, there is still room for legal maneuver. We can bring the case to the administrative court. In fact, the Supreme Administrative Court has the jurisdiction to review the legality of such royal decree.
Right.
Now, we have to remember that since the Constitution and the Criminal Procedural Code does not require specific criteria for this type of royal pardon, one has to question what sort of legal grounds are we going to challenge this decree.
Right.
In my opinion, has to be the general principles of constitutional law, that is the rule of law, the principle that the power must be balanced between the executive and the judicial, as well as the legislation, the legislative branch. When we talk about granting forgiveness for someone who has not even served in the judicially sentenced conviction, then it begs the question, what is the use of the judicial system anyway?
Right.
If we can grant a pardon to somebody who has not even served his sentence, then we don't really need to bother with the correction department sending someone to sentence. We just only need to wait for the good day and ask the cabinet to approve that whether this person should be granting forgiveness. This is a tricky question, and it's a very borderline issue between legal question and political question. My comment would be for the people to remember that this is a society governed by law. The law allows the government to present this law to the king, but the law also allows the people to challenge this law before the court. But it is not for the court or for the people to use force or any illegal means to challenge the attempt by the government to present this law. That is not the way of the rule of law in a democratic society.
Right. Now, final questions, because we don't have the details of this meeting presented to us. Do you think that the petition for the royal pardon, finally, if it managed to get certain number of signatures, would it be too late if, the progress has gone to the last stage?
Well, there are several steps that needs to be made. Now, according to the news, the cabinet plans to send the draft decree to the Council of State, which is simply the legal advisors of the government. The Council of State would then revise the draft, send it back to the cabinet.
Right.
Then the Ministry of Justice would have to coordinate with the cabinet and the Royal Palace, the office of the Royal Palace. And in the past, I believe that the Royal Palace have coordinated with the government in the way that there are adjustments in the draft legislation, and in my opinion, there is no specific or fixed rule for the process to be changed at certain stage. So anything could happen from now on.
Right.
If I may leave one observation, Kun Jerawi and Kun Suthapat, if we think back perhaps 2 or 3 months ago, there's another big controversy concerning Niti Raj proposal about clearing up the decisions stemming out from the coup d'etat and bringing the process back to the new, bringing up the new case before in a normal circumstance. I would like to leave a food for thought question for the audience tonight. Let us compare the two scenarios. The first scenario being the royal pardon being done secretively by the cabinet, presented to the king somehow, and we are now worried whether it's going to be helping Mr. Thaksin against the rule of law. I'm not exercising any personal judgment. I'm just describing the status quo versus the other proposal by Nitirat, or the law professors from Thammasat University, who proposed that the people present the amendment of the Constitution and pass it by way of referendum. So there must be certain ways of negotiations how we're going to deal with the technical issues of how we're going to clear up Mr. Thaksin's conviction from the previous cases stemming out from the coup d'etat and bringing him back to the current justice system. If he's proven innocent, then he's innocent. If he's guilty, then he's guilty as charged. Now let us think tonight which concerns you more, which worries us more. And now I think that would leave some room for us to revisit the Nitirat proposal in light of the current controversies before us today.
Right.
Well, we have to say thank you so much, Kun Weerapat, for joining the program today.
My pleasure always. Thank you, Kun Chiravi, Kun Suthapan.
สวัสดีค่ะ